the 5.
Okay, let's start.
So it's my great pleasure to introduce my friend Roy Berg, and I'm going to let him introduce himself. Let me just get out what I wrote down here. So I've known Roy for about what, 25 years. We're active in a couple other organizations, including Phi Alpha Delta. You went to Loyola, right?
Law school, I went to John Marshall, a place you may know well.
Yeah, I guess. And you had Ann Luzine for one of your professors.
I sure did. And
Yeah.
Still a good friend, and we're active together on a CBA committee, Law and Literature. Ann is terrific.
And he's been a long friend of both the Decalogue Society and me, as well as in Phi Alpha Delta and some other organizations. He's a very prominent, I believe, and know, a very prominent immigration lawyer and a real advocate in that area, and that's what he's going to talk about today.
Cliff,
So,
thank you very much. If I can go ahead, thank you, Cliff, and thank you, Steve Ross, as well, for inviting me to take part. And thank you, Aviva, and all the members of Decalogue. It's really an honor for me to speak to you today. And our topic is going to be immigration law yesterday, today, and tomorrow. We're going to incorporate the concept that went out earlier about amnesty and legalization and different aspects of immigration law. As Cliff mentioned, I've practiced immigration law since I finished John Marshall in 1984. Believe it or not, Cliff, it's 40 years. I'm a sole practitioner, and I'm licensed to practice before the Illinois Supreme Court, the U.S. District Court, Seventh Circuit Court of Appeals, and the U.S. Supreme Court. But my practice is mostly based on removal defense, family immigration, and asylum law. I've been active in another group called the American Immigration Lawyers Association, and am a past Board of Governors member of that organization. Let's just talk about some basic concepts about immigration law. As I said, we're going to talk about immigration law yesterday, today, and tomorrow. So a couple of thoughts as we go into this. If I can quote from your Bible, from Exodus 23, verse 9. Thou shalt not mistreat an alien. You well know how it feels to be an alien, since you were once aliens yourself in the land of Egypt. A little poem that's on the Statue of Liberty, written by a Jewish activist who worked with resettling Jewish refugees in the late 1800s. She wrote a poem as part of a fundraiser for the pedestal for the Statue of Liberty. And if you go there today, you can see it's on the inside of the base. It says, toward the end of it, keep ancient lands, your storied pomp, cry she, with silent lips. Give me your tired, your poor, your huddled masses yearning to breathe free. Wretched refuse of your teeming shore. Send these, the homeless tempest tossed to me. I lift my lamp beside the green floor. So with that said, let's talk a little bit about how we got to where we are in immigration law today. And I think we've got to begin by looking at the Declaration of Independence, because immigration is deep in our DNA. So if you look at the Declaration of Independence, among the reasons listed by the colonists who were breaking with the most powerful empire in the world at the time was this clause. The king has endeavored to prevent the population of these states for that purpose, obstructing the laws of naturalization of foreigners, choosing to pass others to encourage their migration thither. So one of the reasons given, therefore, by Tom Jefferson and the others who wrote that document and the others that signed on to it, was that the king was making it harder to immigrate to the colonies and making it harder to become a full citizen of the empire. And for that, they declared their independence, fought a war, and then 11 years later, the Constitution. And in it, Article 1, Section 8 contains the following, that there shall be a uniform system of naturalization. You look at the Bill of Rights, it doesn't talk about citizens, it talks about persons, people, the accused, not citizens. The concept of citizenship was developing over time. Just who was a citizen? For example, is a child of a slave, or was a child of a slave a citizen? Did a slave have any rights to freedom? We saw that all come to the head with the Dred Scott decision. Before we get there were other laws that were passed. John Adams, when he became president, pushed through a series of laws called the Alien and Sedition Acts, which expanded the time of naturalization, which had been 2 years, to 14 years. He made it easier to deport people. In fact, he was the first president to sign deportation orders for 3 citizens of France. To give you an idea, Now, a lot different. Many more people are deported. So the early 1800s, immigration then, after Jefferson came in, immigration was generally unrestricted. The state of New York tried to pass a law restricting immigration into both the state and the city, but that restriction was turned to be unconstitutional and reversed by the U.S. Supreme Court. So then it turns to the 13th Amendment to eliminate slavery, and then the 14th Amendment as to exactly who was a citizen. Now, we know the 14th Amendment says everyone who is born or naturalized and subject to the jurisdiction thereof is a citizen of this country. The battle that's going on now through Project 2025, and we'll talk about a little bit later, is can birthright citizenship be narrowly interpreted, only include those who are born to U.S. citizens or those legally in the country. After the 14th Amendment, 1875 saw the enactment of a law for the exclusion of convicts and prostitutes. 1882, we saw the rise of anti-Chinese prejudice in the United States with the Chinese Exclusion Act of 1882, followed by the Japanese Exclusion Act. In 1882 also was the first general federal immigration law, which included a head tax of 50 cents and excluded idiots, convicts, and persons likely to become a public charge. For the first time, those words were added to the laws of the United States. 1891 created the Bureau of Immigration. 1903, in response to the McKinley assassination, provided for the exclusion of epileptics, insane persons, professional beggars, and anarchists. An Immigration Act of 1907 modified some of that. But then in the 1920s, with the rise of anti-Semitism, with the rise of anti-immigrant fervor, the rise of the Ku Klux Klan, the National Origin Quota Act of 1924 was enacted. And it established a permanent national quota system, which remained fundamentally intact until 1952, and then when a major change happened in 1965. In 1952, the Congress enacted the McClellan-Walter Act, which was passed over the veto of President Truman, and it established the basic structure of the Immigration and Nationality Act as we see it today. So the 1952 Act, or the INA, is still the basic act that we use today, though it's been amended numerous times since then. 1965 amendments changed the quota system, and basically was a response to a book written by John F. Kennedy, a book called A Nation of Immigrants, which was the law was passed and enacted, greatly expanding the quotas, particularly for people from Southern Europe. Up until that point, Italians and others from Southern Europe had a great deal of difficulty in immigrating to or gaining full status in their country. 1976 to 78, there are amendments changing the quota system. And then we get to 1980, the Refugee Act. Now, following World War II, Holocaust, the Geneva Convention tried to establish certain bases and ideas on how people could be protected, including persecution. And the Geneva Convention established that there were 5 basic reasons that a person could seek refuge status in another country. That was their race, their religion, their nationality, their political opinion, and their membership in a particular social group. Well, it took us until 1980 to really, in the United States, codify that into the Refugee Act of 1980, which is the basis still for our asylum law today. Now, in 1986, you may recall, we had the enactment of IRCA, the Immigration Reform and Control Act, signed by President Reagan on November 6th of that year. That had been in response to a commission that had been set up by President Carter in the late 1970s, which was the idea was to address increasing numbers of undocumented immigrants coming to the country seeking employment. The commission was headed by a former president of Notre Dame University, Ted Hesburgh, and it came up with 3 basic recommendations. Number 1, a general amnesty for people who had been living here for a while, a period of years. Number 2, an employer sanctions provision by which the employers would be penalized for hiring people that are undocumented. And 3, a provision to protect against discrimination simply because a person sounded or appeared to be foreign. Well, that penned through the Congress, and finally it was passed and enacted in 1986. That began a 1-year program 6 months later of applying for amnesty. We had the government set up over 100 different amnesty or legalization offices. At the time, I was with an organization called Travelers and Immigrants Aid, which is now today called the National Immigrant Justice Center. Over 4 million applications were filed, and many of those people were granted lawful permanent residency. Now, the employer sanction provisions also were in effect the same day the law was signed and still are in effect today. Employer sanctions provisions provide that an employer must, within 3 days of hire, complete a form called an I-9, which both the prospective employee and the employer must complete the form under penalty of perjury, through which the employee states what their status is in the country and how they have permission to work. The employer then signs off and checks the boxes as to what documents were checked. It must be a document establishing identity and a document establishing the authority to work. For example, it could be a valid driver's license and a valid Social Security card, or a valid U.S. passport, or a valid permanent resident card. Fines have increased over time, and so now many employers are being very scrupulous about completing and storing and keeping the information on the I-9. After that, about 4 days after IRCA was signed, a bill that had been introduced by Senator Paul Simon, called the Alien Marriage Fraud Act of 1986. And that created something called an oxymoron called permanent conditional residence. So you've heard the term perhaps green card or permanent residence or LPR, lawful permanent resident. So what Senator Simon established in his law in 1986 was that a person who had obtained lawful permanent residence through marriage to a U.S. citizen will only be conditionally here in the country for 2 years if they had been married for less than 2 years on the date they got their status. Let me say that again. So if a person is obtaining status in the United States through marriage to a U.S. citizen, if they were married less than 2 years when their case is approved, they are only granted conditional residence for 2 years. They then must return with that same spouse 2 years later to try to get the conditions removed. But we all know that not all marriages last that long. People separate, people divorce, and so there are provisions put in for waivers. So there are people that have been married to a permanent to a U.S. citizen for less than 2 years, get the conditional residence, and then have to have a waiver to keep their status. A couple of other things that went on in the 1980s was something called the Omnibus Anti-Drug Abuse Act, which created something in the Immigration Act called an aggravated felony. Then there was a provision called IMAC 90, which expanded what an aggravated felony would be under the law. And then we came to 1995, and in Oklahoma City, Harry McNichols and Timothy McVeigh blew up the federal building. And so there were a series of laws that were introduced, including something called the Anti-Terrorism and Effective Death Penalty, which at the last minute had 10 very restrictive immigration provisions added, even though Timothy McVeigh and Terry Nichols were both U.S. citizens. So that greatly restricted a waiver called the 212C that I've been having a lot of those types of cases. Permanent residents who have been convicted of crimes could ask for a waiver under 212C. But DEPA, the Anti-Terrorism and Effective Death Penalty Act, effectively repealed that until several years later, when Justice John Paul Stevens, in an opinion called St. Cyr, allowed for some of that to continue if the person had pled guilty before the enactment of that law. Later that year, a law called IREA, Immigration Reform and Immigration Responsibility Act, was enacted September 30th of that year. And that was a greatly very restrictive law. It eliminated many rights that immigrants had under the law, barred judicial review of many cases, added something called the one-year asylum rule. So now we know that many of the migrants being bussed up here from Texas by Governor Abbott, in order to apply for or to be granted asylum, they must apply within 1 year crossing our border. That's from the 1996 law. If a person overstays their status, so they come and been here illegally for a year or more, they leave, they can't come back for 10 years. I had a couple of my clients were involved in a documentary movie that were impacted by this. It's called Tony and Janina's American Wedding, a deportation love story. It talked about how the 96 law ripped that family apart for 4 years before we were finally able to bring Janina and her son back from Poland. There's something else called the stop time rule in the 96 law that said if you didn't have a certain number of years in the country before your place in removal proceedings, you're barred from any types of relief. Also, there's something called 287G, which was a provisional law through which local communities could sign on to work in close concert with the INS at the time it was called, and immigration and enforcement. Hazleton, Pennsylvania is an interesting place that was one of the initial signatories of 287G. It's also a hometown of a man you may have heard of called Joe Madden. Joe Madden, of course, was manager of the Cubs when he took them to the World Series. And Joe Madden was a very outspoken opponent of 287G, and he set up a center in his hometown of Hazleton to help immigrants and refugees. But also 287Gs, there are still some communities that did sign on to it. Basically, it deputized local and state police to be immigration officers, and through which they would get money from the federal government to do that. So it became very attractive for somebody to do that. As I said, the 1996 law was very harsh, cruel, restricted rights. In the CARA, the law that was passed the following year, that ameliorated some of the provisions, but still most of the harsh provisions of the 96 law remained in effect. We had two laws that helped children that were enacted shortly thereafter, the Child Citizenship Act, the Child Status Protection Act, two laws that expanded the rights of children. Even the idea of the Child Status Protection Act, a child who turns 21, who is undocumented, loses the right to adjust status to their parents. Now, the Child Status Protection Act said if the paperwork was started before the 21st birthday, that's a right to adjust status and become a permanent resident will continue. Also, around the same time was something called the Life Act, which provided an additional visa called the V visa, and also extended the right for a person to apply for permanent residence, even if they had overstayed their status, if their application was filed before May 1st of 2001. That all came September 11th, 2001, in which, as we all know, immigrants are people from other countries, flew planes into buildings, and caused the death of about 3,000 of our citizens and immigrants living in this country. Then 6 months later, on the front page of the New York Times was a man holding up two notices of approval. The man was the owner of a flight school in Florida, and the two notices of approval were the notices of approval for extension of the M1 visas of a man by the name of Muhammad Atta and his roommate. Muhammad Atta, you may recall, was the man who flew the first plane into the World Trade Center. And so the head of the INS at the time, James Ziegler, was called to Congress and called to testify before 5 separate committees as to how this was possible. And 6 months after 9/11, two people who had participated in the murder of many other people, how was it possible that they were able to get extensions of their status? And he answered, actually, we approved it before 9/11, but because we had contracted the mailing out to the lowest bidder, they didn't get mailed until 6 months later. Nevertheless, the Congress was quite irate at this whole thing, rightly so, and Mr. Ziegler resigned a week later, and a massive piece of legislation was enacted called the Homeland Security Act. Homeland Security Act limited the INS and created new agencies within a new department called the Department of Homeland Security. And these three agencies that deal with immigration now on a day-to-day basis are USCIS, that's U.S. Citizenship and Immigration Services, ICE, Immigration and Customs Enforcement, and BCP, Bureau of Customs and Border Protection. That all went into effect in 2003. So the old INS that you may have heard of or talked about no longer exists. It's now DHS is a department, a very large department within the U.S. government. It has those three basic immigration agencies. USCIS deals with asylum applications, naturalization applications, petitions. BCP deals with things at the border and at the airports, and ICE is for interior enforcement, detention, and deportation. So the next law that happened in 2005 and it impacts all of you here, something called the Real ID. If you have a Real ID driver's license, it has a little white star in the upper right-hand corner. And starting next year, in order to get on a plane, you're going to need one of those Real ID driver's license or another form of ID that shows that you're legally in the country. So the Real ID Act brought that into existence, was passed and enacted in 2005. Some state legislation that's also happened over time. Here in Illinois, for example, now we are a sanctuary state. We had something up until very recently called TVDLs, temporary visitor driver's licenses for the undocumented. Those now, because of something that happened in Florida, there's been a change in our law here in Illinois. So a person can get a driver's license even though they don't have a social security number. TVDL was designed for those people. What happened last year in Florida, and a couple other states were starting to follow suit, is the governor of Florida, Mr. DeSantis, and his legislature enacted laws saying that a driver's license for the undocumented would not be a valid driver's license in Florida. So a number of people from Illinois who had TVDLs, who were planning or did go to Florida for vacations, or visit Disneyland or one of the amusement parks there, who decided they weren't going to go because it would be too risky. Because driving them in a TVDL in Florida would not be a valid driver's license, could subject them to arrest and then being turned over to immigration because with a TVDL, you don't have a social security number, and obviously you didn't have lawful status. So here in Illinois, steps were taken, and as of July of this year, people, even though they don't have a valid social security number, can get a valid driver's license. They cannot get a real ID driver's license that we talked about earlier, but they can get a driver's license allowing them to drive in Illinois. A couple other concepts of state law. DeSantis, in addition to the law that I talked about, driver's license, also enacted a number of very, very harsh anti-immigrant laws. It's causing many of the undocumented to leave the state there, and it's also causing a great deal of hardship. Arizona, a number of years ago, passed something that was called SB 1070 under the former governor, Chan Brewer. That law went up to the Supreme Court, and it was reversed. But some states have done things that are beneficial to immigrants, others have not. Here in Illinois, as I said, we're a sanctuary state. To the east and west of us, our laws in states are very, very different from what we have here. A number of years ago, Texas enacted or passed a law saying that the undocumented children did not have the right to public education. That case went all the way to the Supreme Court in a 5-4 decision called Plyer versus Dell. In the majority opinion, the Supreme Court wrote that it made no sense to have a whole class of people uneducated simply because they were not able to obtain lawful status in the country. In early 2000, two teachers approached Senator Durbin, and they explained to him that they had a prodigy as their student, a junior in their high school, who was the best cello player they had ever had as a student. And she had been offered a full ride to Juilliard. Problem was, she didn't have a good social security number, so they were going to allow her to attend Juilliard. So the teachers went to Senator Durbin, and they told her about this, and he then drafted and introduced something called the DREAM Act, 2001. And the DREAM Act, unfortunately, never got enough votes to pass both houses. And then on December 8th, 2010, I remember that day because I happened to be there for the showing of the movie that I talked about earlier on Capitol Hill, Tony Jana's American Wedding. Down the hall at the Capitol Visitor Center from where they were showing the movie, there was a room full of students, and the noise coming out of the room was like they were having a huge party. So I said, I'm going to go join them and see what's going on. I went down to that room, 3 floors below the U.S. Capitol, the Capitol Visitor Center, and in the room was full, as I said, of young people. And on the wall, they had a huge screen with C-SPAN on it. And it was the vote on the DREAM Act, December 8, 2010. And in order to pass something, of course, in the U.S. House of Representatives, you need 218 votes. And when I walked in the room, the count was 204 and I think 150 against. So every minute went by, another vote, another vote. Finally, they hit 219, and they went wild. You thought they all won the lottery. The proposal, Senator Durbin's proposal from many years before, the DREAM Act, had passed the House of Representatives. And the various people came in, Senator Congressman Gutierrez and Congressman Roybal and other Hispanic congressmen came into the room, and everybody was jumping up and down and congratulating them. However, they then realized, of course, it has to pass the Senate. In order to pass the Senate that year, they needed 60 votes. Why? Because 3 senators blocked it with a filibuster. So the final vote in the U.S. Senate that they needed to break the filibuster was 60. They only got 56. So the DREAM Act then died in the end of December of 2010. A few weeks later, Senator Durbin and 21 other senators wrote President Obama, and they asked him not to deport anyone who might have benefited from the DREAM Act. And nothing happened from that January of 2011 until June 15th of 2012. On that day, President Obama changed the lives of hundreds of thousands of young people. He walked out in the Rose Garden and he announced something called DACA, Deferred Action for Children of Americans. Deferred Action for Childhood Arrivals, DACA, D-A-C-A. So with DACA, we have about 650,000 young people who had been here since before their 16th birthday, and they would either had graduated high school or were attending high school, didn't have a criminal record. They were able to obtain a 2-year work card, a social security card, and protection against deportation. So a very successful program. People were able to renew their cards, finish their education, get good jobs, start their families, but only for 2 years at a time. In the campaign of 2016, then candidate Donald Trump and others on the Republican side all promised to end DACA if and when they got elected. Sure enough, Mr. Trump was elected, and one of the first things he did when he became president, in addition to signing a number of very anti-immigrant provisions and executive orders, was he appointed Jefferson Beauregard Sessions III to be his Attorney General. Jefferson Sessions, when he was senator, was one of the 3 senators who had filibustered the DREAM Act in December of 2010. And just Mr. Sessions announced that he was going to be issuing an order ending DACA. And sure enough, that's what he did in September of that year. 4 separate challenges were filed to the executive action ending DACA. The one that won was an action filed by the NAACP. And basically, the Supreme Court held in that decision that yes, President Trump and Mr. Sessions could end the DACA program. However, they didn't do it correctly. However, shortly after that, the state of Texas, under the leadership of Greg Abbott and several other states, filed another lawsuit, this time with the courtroom of Judge Andrew Heinen in Brownsville, Texas. And they contended that President Obama never had the authority in the first place to sign DACA. And sure enough, Judge Heinen agreed. The other thing that he did is he also blocked a provision that President Obama had also signed in November of 2012. And that was called the DAPA program, Deferred Action for Parents of Americans. Under the DAPA program, individuals who had U.S. citizen or permanent resident children and would live here at least 5 years could get a similar protection to what the young people under DACA got. In other words, a work card, get Social Security card protection against deportation. So in February of 2015, what happened then was first the DAPA program was blocked. However, it wasn't until President Trump came in that the other action, trying to block DACA, saying it was illegal from the beginning, that he ruled on that. And sure enough, Judge Andrew Heinen determined that President Obama did not have the authority to sign the DACA program in the first place, even though more than 650,000 young people had been granted protection under it. The case went to the Fifth Circuit Court of Appeals. President Trump leaves office. President Biden comes in. His administration is vigorously defending the DACA program, and they published regulations in an attempt to deal with the objections raised by Texas and found objectionable by Judge Andrew Heinen. And the Fifth Circuit then sent the case back to Judge Andrew Heinen, who then determined that these new rules promulgated by the Biden administration did not remove the illegality of what President Obama, in their opinion, President Obama had done. So the case now is back at the Fifth Circuit. There's literally hundreds of thousands of young people. They're now, they initially applied, many of them in 2012. Now many of them are in the late 30s or 40s. They've established businesses, families. Many of them are in the medical profession. There's more than 30,000 teachers right now in California on DACA, 34,000 national, many in California and DACA. And their lives really are hanging in the balance right now as to what will happen in the future. Among the things that have been discussed and proposed for the next administration, should Mr. Trump come back in, is the immediate end of DACA. So many of those young people are really living in fear as to what's going to happen in the future. So talk about some other things that have happened. As I said, when he first got into office, President Trump in January of 2017 signed a number of executive orders. Number one, he signed an executive order saying that basically everyone who was undocumented, whether they had just overstayed or a student visa, or whether they had crossed the border, whether they were a terrorist or someone completely innocent of any crime, would be a priority for deportation. They didn't have lawful status of some kind. That, of course, immediately proceeded to jam the immigration courts, as the judges were not granting continuances, they were not administrative closing cases, the ICE was not exercising prosecutorial discretion, and the backlog got bigger and bigger and bigger. Other thing he did on the first day was to sign executive order basically barring people from many countries being able to return to the country, even people who had been lawful permanent residents who were simply returning from a trip abroad. So under what he did, under what Trump did, many families were ripped apart, many harsh provisions. The whole DACA program, as they said, was put in jeopardy. And he pushed for some very, very even tougher legislation. Then he ran, of course, again, and in November of 2020, President Biden was elected. And a number of things that he did, by the way, was to rescind many of the executive orders that President Trump had put in place. The other thing he did was to nominate a man from our area to be Attorney General, Merrick Garland, who in turn reversed a number of the decisions that Jefferson Beauregard Sessions, former Senator and former Attorney General Sessions, had put into place. Then basically, as a practitioner, I could tell you that things were much, much better under President Biden, and still are much better than they had been under President Trump. We all recall, I'm sure, when President Trump, then at the time a candidate for office, rode down the escalator at Trump Tower in the summer of 2015 and talked about what he was going to do. Made some very derogatory comments about Mexicans and other immigrants in general. I always found it a little funny because why is this man so anti-immigrant? 2/3 of his wives are immigrants. But nevertheless, he was very effective at making things much more difficult, much harsher for non-citizens in our country. He had a man working for him that you may have heard of, Stephen Miller, a man who proposed and got over 400 different changes in policies, all of them very harsh anti-immigrant, put in place under the Trump administration. Another thing that Trump did was to basically end what we call TPS, temporary protected status, that had helped a number of people from countries like Haiti, El Salvador, Syria, Nicaragua, people who their home countries were undergoing great upheavals or war, particularly countries like Haiti, we know now is still undergoing a great deal of upheaval, gang violence. And so what President Trump did, he was trying to eliminate temporary protected status for these protected groups. President Biden came in, he reinstated temporary protected status, reinstated prosecutorial discretion, and reformed the priorities as to who would be a priority for deportation. And the number one person or group would be terrorists. Number two, serious or dangerous criminals. And number three, recent arrivals to our country. So those priorities were challenged by Texas and Louisiana law and Florida in a lawsuit in which they contended that the president couldn't establish those priorities. The Supreme Court, in a decision called U.S. versus Texas that came out in June of 2023, said that's all within the discretion of the executive, who is a priority for deportation, who the executive wants to deport, and that cannot be mandated by the courts. Another thing that's happened that happened under Trump that was changed under Biden was a proposal first to make the naturalization test much more difficult, increasing the number of questions you had to get correct, making the form more difficult, increasing the fees. Those were all reversed under Biden when he came in. So a couple of other things I definitely touch on, and then go to what I see happening in the future. First of all, U.S. citizenship. What is a U.S. citizen? And basically, the 14th Amendment, we know a person who is born or naturalized. And the other clause that we sometimes forget is subject to the jurisdiction thereof. Ken Cuccinelli in Project 2025 wanted to eliminate the concept of birthright citizenship. I don't know if you've heard about perhaps Project 2025. It's a 900+ page wish list of the Heritage Foundation, very regressive, very harsh, particularly anti-immigrant. And it would, there's 40 pages written by Mr. Cuccinelli in that book as to what he and the Heritage group wanted to bring back. Many of these are harsh, cruel, very anti-immigrant. And certainly it's something that I fear will happen if Mr. Trump is reelected to office. Most of the concept in law of derivative citizenship, and that's basically statutory. And basically it's a provision that says, okay, if you are here and your parent becomes a U.S. citizen and you have a green card and you're under 18 when that happens, you have a claim to derivative citizenship. And the question was, what about a child born in the U.S. who undocumented are Chinese parents from 1898? And the Supreme Court said, okay, we interpret the 14th Amendment to say that that Chinese child born on U.S. soil to Chinese parents who are not here as U.S. citizens, that child is a U.S. citizen also. So that's a very important case called U.S. versus Wong King Ark from 1898. We have also a couple concepts in citizenship law, both in our country and internationally. One is called jus solis, and the other is jus sanguinis. Jus solis is citizenship through birth in the country by land. The other is jus sanguinis, which is birth citizenship through blood, the blood of your parents. So requirements today for naturalization, if someone wants to become a U.S. citizen, basically there's a requirement of good moral character as defined in the INA. What's good moral character? They need to be a resident for 5 years, or 3 if they've been married to a U.S. citizen the whole time, or if they've served in the military. There's no requirement for time. They can be a permanent resident, apply right away. They have to have the ability to read, write, and speak the English language. That was a requirement added a number of years ago, which initially President Teddy Roosevelt tried to overturn or veto, but the Congress passed it over his veto. So you have to read, write, and speak the English language unless you fall within an exception. A couple of exceptions are, if you're over 50 and you've had your green card for 20 years, you don't have to speak English. If you're over 55 and you've had a green card for 15 years, you don't have to speak English. Or if you have a form completed by a doctor certifying that you do not have the ability to learn how to read, write, and speak English because you have a physical defect, or you suffer from something like Alzheimer's or dementia, you can get a waiver of the citizenship requirement. I had a case once with a client who was blind, and it was a huge battle. But they finally agreed that my client didn't have to read English, even though he was blind. But it took an appeal and a lot of battle, but we finally got him natural. Also have an established knowledge of history, government, and constitution. Once again, you could have that waived if you have a certain medical or mental condition. The form is called, to become a citizen, is called an N-400. Under Trump, they expanded that form, made it much more difficult. Under Biden, he's made it shorter. Biden has also reduced the fees for people who have less than 400% of the poverty guidelines as their income. Under the current administration, people are encouraged to apply for citizenship. The process is much quicker, much easier. You may have seen the news last week about 900 people, including one of my clients, was sworn in at Wrigley Field in a huge ceremony. There's an article this week in the New York Times about the great increase in the number of people applying for U.S. citizenship. There's also a special program for members of the military, and the fees are waived for members of the military if they want to become citizens. I want to talk real quick about a case that I know that many of you are familiar with. It's called Keithley versus Holder. It was done by Richard Haynes at the Seventh Circuit. It was made into a movie called The Courtroom. Brilliant lawyering by Rich, a hero of mine, and many others. If you haven't read it, it's Keithley versus Holder, Seventh Circuit case from 2012, in which a woman who basically registered to vote while at the Secretary of State's office, basically, and then voted, even though she was not a U.S. citizen. And then she tried to get her green card and was blocked from doing so because she had voted without authority from the U.S. government, although she was given registered to vote as an Illinois voter, even though she wasn't a U.S. citizen. And the movie, if you've seen it, The Courtroom, depicts exactly what happened. It's taken from the court transcripts. She had lost in front of the immigration court here, lost the Board of Immigration Appeals, and Rich won the case. And brilliant lawyering at the Seventh Circuit went back down to the immigration court, and she finally won her case. Can citizenship be taken away? It can be taken away. First of all, if a person obtains citizenship through fraud or deceit, or not telling the full truth, or if they obtain permanent residence unlawfully, can be taken away for other expatriating acts, treason, or fighting for a foreign government against our country. And under Trump, they established a denaturalization unit, and they went after people to try to denaturalize them. Biden has not kept that unit going, but Mr. Trump has promised to reinstate that if he gets back in office. A very interesting area of law that I do a lot of work in is called crimmigration. It's the interplay of immigration law and criminal law, and how these two areas interface. And a lot of it has to do with whether or not the person has been convicted of something called crime involving moral turpitude. Now, that concept is not defined in the law. And in 1952, there was a famous case out of Chicago involving an Italian immigrant who was making wine in his basement, not paying the tax on that wine that he made in his basement. And I guess he was making more than the requirement of more than you can make. And he was determined to have been convicted of a crime involving moral turpitude, not paying the tax. Taken all over the Supreme Court, and Justice Jackson, who you probably know was the lead prosecutor, the Nuremberg trials, wrote a very brilliant dissent in which he said this concept of crime involving moral turpitude is void for vagueness. It's unconstitutionally void for vagueness. Nobody knows what it means. But unfortunately, he didn't win. And then in 2016, in a concurrence in a case called Harris versus Lynch, Judge Posner was at the same on the Seventh Circuit at the time, that wrote how antiquated and how vague and nebulous this whole concept is. But nevertheless, yesterday I had a very complex case. A client of mine who's currently being held by immigration in Coy County Jail in Oklahoma, and the issue was whether or not him attempting to disarm a police officer when he was intoxicated is a crime involving moral turpitude. Police officer was intoxicated, my client was. So the judge closed the case for decision, but had a very long argument as to whether or not that is a crime involving moral turpitude. Was it morally turpitudinous for my client, Springfield at the time, to attempt to take or attempt to disarm a police officer? So that's the term that we deal with a lot. Another term is called aggravated felony, which, as I mentioned earlier, was first added to law in the late 80s and has expanded greatly since then. Just what is an aggravated felony? Well, there's a whole laundry list of crimes that are, including very serious crimes like murder. Other crimes can be theft if the sentence imposed is a year or more, or burglary, the sentence imposed a year or more. So it's not only what the crime is, but what the sentence is. Or if it's an amount defrauding the government of more than $10,000, or another type of fraud of more than $10,000, it's classified as an aggravated felony. Why is that term important? Because the term aggravated felony restricts many people from becoming U.S. citizens, and is also a ground of deportability for which there's very, very little that can be done to try to stop it. Touch on now, if I can, real quick, what I see happening in the election.
Roy, let's
Yes.
stop for a minute. We haven't had anybody put out a question, and maybe they're all shy, which is unusual for this group of people. But
Well,
I
maybe
don't
I've
know.
been talking too fast. But if anybody has a question, I think I'd be happy to take
We can put
questions.
it in the chat, but more than that, is there anybody who has some question that they want to raise? You can unmute and ask now. Otherwise, we'll let Roy go on.
Now, I only have 50 more pages in my outline, so I'll try to speed it up.
I know, you're always over prepared. Anybody at all? Hopefully.
Yeah, actually, they can't unmute. They would need to raise their hand or put it in the chat.
All right. Anybody have a question? You can raise your hand. Not seeing any. We'll wait for Roy to come back in a minute. You know, it used to be moral turpitude was the only way you could get disciplined as an attorney. But the problem was you didn't know you committed moral turpitude till after you were disbarred.
Well, I think it's still in the Illinois disciplinary rules in a lot of states, isn't it?
Yeah, but not in Illinois. We don't have moral turpitude anymore. But if, you know, because it's so hard to define. I mean, it's a, yeah, Steve, you can, let's see if we can unmute you. Can we, how do we unmute him? Do I do it, Aviva?
Yeah, just ask him to unmute.
Unmute, Steve, if you can.
No, press the thing that,
Oh.
Yeah.
Did it work? Can you unmute, Steve?
Yeah,
Yep.
now I can unmute.
Hi,
Is
Steve.
it possible to put some of the it sound like you've been interesting, you've been going a mile a minute. Is it possible to put your outline in with documents so we can have access to it?
Absolutely. Be happy to do that. Let me just polish it up a little and I'll get it out.
Send it to me or Aviva and we'll put it on. I have one question. Can you still buy yourself in for $500,000?
One of the things that Cliff is raising is this concept of what's called an EB-5, and that's a way you can get status through investment in a company in the United States. The statute says 10 million, but if you do it in a low income area, you can do it for 5 million. You have to create 10 jobs. You get conditional residence for 2 years. At the end of the 2 years, you have to show that you invested, put money at risk, you hired at least 10 people, and you kept 10 people for those 2 years. There's also ways to pool money with other people to make it happen. So those are called EB-5s. Yes, you can do it. It's been in the law since 1990. Okay. Sorry, I've been talking too fast, but I certainly, Steve, I'll polish up this outline and make sure it gets out in the next day or two. But thank you so much for asking. Another-
Anybody else got any questions, got a hand raised? Otherwise, we've done our obligation to allow people to ask questions, and we'll do it again at the end. Okay, go ahead.
Well, it's something that just happened on June 18th that's going to help many, many people, many of my clients, is something that President Biden announced on June 18th of this year. And it's calling, basically, it's what's called a parole in place program. Many people who come to our country without inspection or documentation, who are married to U.S. citizens, in order to get their status, have to leave our country for 10 years before they can get their green card. Or they have to get a special waiver. Those waivers are now taking about 4 years to adjudicate. So what President Biden has proposed is for individuals who are married to U.S. citizens on June 17th of this year, who have lived in the country for 10 years, and who do not have a criminal record, they can apply to have their undocumented or uninspected entry changed to what's called a parole entry, parole in place. Parole usually happens at the border. We have several types of programs where you can get parole retroactive here in the interior of the United States. So it's going to be a life changer for, they believe, at least 50,000. I think it's going to be more people who are going to say, yes, I was married to a citizen on that date, June 17, 2024. Here's my proof I've been here 10 years. I have a clean record. They'll then be able to get the parole in place, get a work card, and eventually apply for permanent resident status without having to leave our country for up to 10 years. The program is scheduled to go into effect on Monday. We don't have the final rules yet. We don't know what the form is going to look like, but hopefully they'll have all that worked out between now and Monday.
Do
That's
you
another
have
plus.
been
Go ahead.
do you have to have been married in the States?
No, you have to be married to a U.S. citizen. You don't have to be married in the United States. But you have to be married to a person who is a U.S. citizen on June 17th, 2024. You have to be married to that person as of that date. So there's no requirement in what we've seen so far. The final rules were supposed to be published in the Federal Register before the 19th. They haven't been as of this morning. But it's going to mean that people, as I said, who are married to a U.S. citizen as of June 17th, 2024, who've been in the country for at least 10 years, and then apply for this special program. It's going to help many, many people obtain employment authorization, a good Social Security card, and a path to permanent resident status without having to leave our country for 10 years. So that's something that is brand new. As I said, scheduled to begin on Monday. We're still waiting for the final rules to be published in the Federal Register. I think the other thing that on the horizon, of course, is the election coming up in November. And the two candidates have very, very different positions and attitudes on immigrants, refugees, immigration, and families. Many of the people that worked in the Trump administration are part of the authors of this thing called Project 2025 of the Heritage Foundation. As I said, the chapter on immigration was written by Ken Cuccinelli, an anti-immigrant zealot. I don't think he would object to me saying that, but certainly he's been someone who's proposed many, many harsh things, both when he was in the Trump administration, along with Stephen Miller, who was an advisor to President Trump on many, many immigration issues. One of the things they want to change, as I said, is birthright citizenship, to have the 14th Amendment interpreted to say that you're not a U.S. citizen automatically, even though you're born here, unless you can establish that both of your parents were leaving the country when you were born. So that's something that they are really pushing for, and they've been after for a long time. And I believe and Trump had talked about it previously, and I believe if Trump is reelected, that's going to be a priority. You know, Trump has said he's not going to be a dictator in an interview with Sean Hannity, except on day one. And we know what he did on day one in 2017, when he signed a number of executive orders, all very harsh, very anti-immigrant, that hurt many, many people. I don't know if you remember, but at O'Hare, there were a number of lawyers, myself included, who went out to O'Hare to try to help people who were not being admitted back into the country, even though they were permanent residents. These people who were returning from a trip abroad from one of the countries on this list that Trump had arbitrarily signed on Friday that he took office, or the day that he took office, now we're not able to return. So they're being told at O'Hare by immigration that if they signed away their green card on this form called a 407, they would be given a visitor visa, be allowed to stay for 2 months. But if they didn't agree to sign that, they'd be held in custody until the determination was made whether or not they could be readmitted. So many, many harsh provisions, I think, are going to come. be put in place again if Mr. Trump gets reelected. On the other hand, President Harris, Vice President Harris, former Senator Harris, I went to meet with a number of senators in the spring of 2020 as part of a lobbying group of ALA, American Legion Lawyers Association. And I still remember, and I have a picture of it, outside her office was a big sign saying "Dreamers welcome here," obviously in reference to the Dreamers. Many Dreamers at the time. California had one of the largest numbers of DREAM Act recipients of any country, or any state in the country. So she was very, very pro-immigrant while she was in the Senate, and I believe she'll continue that policy and practice whenever she gets elected this November. And I think she'll strive for what she's been talking about lately, and that is comprehensive immigration reform. And I believe her proposals, in which she will fight for, will be compassionate, will try to keep families together. Whereas Mr. Cuccinelli in Project 2025 is talking about making it far more difficult to immigrate, eliminating, as I said, birthright citizenship, and greatly limiting family immigration. Other thing they want to do is to stretch the process out, and anyone who's not granted a benefit will immediately target it for deportation. So a lot will change if Mr. Trump is put back in office, and I think we'll see a continuation of more pro-immigrant, more pro-family, more pro-humane policies if Vice President Harris becomes our first female president. If there's no more questions, that concludes my remarks. And Steve, I certainly will take your advice and make this outline readable so other people can read it, and we'll try to get it out ASAP. I have sent some other things that I just sent out today. I just sent to Decalogue today, which I think you're going to get later today. And those are some things that include a brief description of Project 2025. And I think it's something that we should all be aware of because this is something that the Heritage Foundation, which is made up, the people that wrote it are made up of many former officials in the Trump administration. So I think that's something we all have to be aware of. If there's no other questions, Cliff, do you have anything else you want to add?
Actually, I have a question, and I'm sorry if you covered it because my internet was kind of going in and out. But assuming that we have that our next president is someone who supports the Dreamers, how much discretion does a president have? How much can be done administratively to protect Dreamers from being thrown out of the country or other, punishments against them?
That's a great question. I think some of them are going to be, and I have some clients who are Dreamers and have the DREAM Act, have the employment authorization and deferred action, who are married to U.S. citizens, and we're going to be able to fix their status that way. There's also provision for work authorization or a path to permanent residence in the executive order that President Biden signed. So those are things that can be done. The other thing is that I believe that President Harris will keep the program going. As we talked about earlier, it's currently before the Fifth Circuit Court of Appeals. And I believe that the Harris administration, if there is such a thing, will continue to fight for the DREAM Act. And I think she has also been on record as supporting DREAM Act legislation as opposed to simply an executive order. And I know Senator Durbin every 2 years reintroduces this legislation. And hopefully there'll be a path for these hundreds of thousands of young people, not just 2 years at a time, but a path for them to obtain lawful permanent residence through legislation. I don't know if that answers your question, but I think that the first thing, if Mr. Trump is in, I think what he's proposed to do and what Project 2025 is saying he'll do is to immediately end the DACA program and to oppose any legislation that would give a path to citizenship for those people.
Steve is asking about all those green card movies with the people marrying and staying. Is it relatively still easy, or do they still look under your bed and ask you all those questions?
Well, that's a great question.
I don't know if that's what Steve is asking. I'm kind of adding to it.
Steve, can you unmute yourself? I want to hear it from you yourself.
It should work, Steve.
There you go.
Yeah, basically, I think at some time I heard that it was relatively easy for a non-citizen to become a citizen by marrying a U.S. citizen. I knew of a couple in college that seemed to be that way. And also, I remember hearing on the radio, there was a woman from Australia at that time who offered $1,000 to get married to a US citizen. And that was all the contact she wanted with that person. She didn't want to do anything, consummate the marriage or anything else.
I've had Las Vegas brides who got imported from Asia.
Those
And
are
that they're
great questions. If I can just comment real quick. So because obtaining permanent residence through marriage to a citizen is a relatively easy path that invites some people, like this woman you mentioned from Australia, or the people you heard talking about, Cliff, that get married in Vegas. The penalties for a fraudulent marriage, in other words, entering somebody with the purpose of
I think you have to stay married to them, right? Isn't that the punishment?
if they get, Cliff, I tell you, you got to go into stand-up comedy, man. Make a lot more money. So the penalties are, if a person is convicted of marriage fraud, penalty for both the citizen and the immigrant is 5 years in jail, a $250,000 fine, and to the immigrant, a permanent bar to ever obtaining lawful status. And I've litigated some of those cases. They're very tough. Let's say someone has been married to somebody, only get a green card, doesn't get the green card, gets divorced, and marries a U.S. citizen, has 5 kids, and that person cannot get a green card through that new marriage, even though the new marriage is valid, because previously they had obtained or they had married someone with the intention solely to get the green card. It was for permanent residence and was not a bona fide marriage. So the other thing, as we talked about earlier, was Senator Simon's bill, 1986, the Alien Marriage Fraud Act. And under that provision, a person married less than 2 years only gets status conditionally for 2 years. So then they have to come back at the end of 2 years and establish again that's a bona fide marriage. And so that's where a lot of them get caught. They'll get caught the first round, they get caught the second round. So it is relatively easy, but the penalties are very stiff. And the harshest penalty to the immigrant is a lifetime bar ever getting lawful status in our country.
I have another question. Hypothetically, if Trump gets elected and puts in legislation that the Fourth Amendment does not automatically guarantee citizenship, could he technically be to have his citizenship taken from him because his grandfather illegally originally immigrated here illegally from Prussia to avoid being drafted?
I think, first of all, let's hope that Mr. Trump, my humble opinion, is not elected again. Secondly, let's hope that he's not able to put those changes into the 14th. But assuming he does, I think there's going to be many people that are going to be facing that situation, perhaps including Mr. Trump. Or the other alternative is Mr. Trump may be in jail. I don't even know if he can he vote now as a convicted felon? Can he vote in Florida? He can, because his case is on appeal, Deborah?
He cannot, because though they passed the legislation, it's been blocked so far unless you could prove that you paid off every one of your obligations under the court for your convictions. And so
Okay, Deborah, can you unmute yourself? Unmute yourself, Deborah. I want to hear what you have to say.
I have to do it. Wait. Okay, go ahead. See if it works.
Deborah, unmute yourself now.
All
There
right,
you go.
as I understand it, because he can vote in Florida because his conviction is in New York. And for some reason, whatever it is, there is something, I can't remember, several lawyers were talking about it on TV, and it was a very interesting thing, but technically he can vote in the federal election in Florida. It's very unsettling, considering how miserable DeSantis has been to people who are convicted in Florida and have served, and there's that new law, and if they haven't paid off every penny, they can't vote. So it seems like a dual standard, but apparently he is allowed to vote.
Thank you for sharing that, Deborah. Well, we'll see what happens. Any other questions anyone has?
Well, we got 5 more minutes. You want to do a little tap dance or something?
I have about 20 more pages in my outline. I could talk about more things. Just let me touch on a couple other things if I can. And that is, let's talk again about how a person can become a citizen. Let's talk about perhaps what members of Decalogue can do. there have been thousands and thousands and thousands of people bused to Chicago by Governor Greg Abbott. There's a story I just read this morning. They were anticipating another 10,000 before the convention starts on Monday, but it looks like that's not going to happen. But there are many, many people who desperately need legal assistance. You don't have to be an immigration law expert. You just be somebody that tries to help someone, point them in the right direction. A number of people have to file for asylum within 1 year of coming. Many of them do not speak English. Many of them have no idea how to go about the process. Those that were at the border are given paperwork, are given court dates 2 or 3 years in the future, thinking that they don't have to file their asylum application until then. That's not correct. Also, people that need help filing applications for employment authorization. What the law says now is that cannot get employment authorization until at least 6 months after you file for asylum. Asylum application has to be filed in the right place. If the person's in removal proceedings, you have to file the application with the court that's jurisdiction over them and certify that they sent a copy of it both to the ICE prosecutor and to USCIS to schedule them for fingerprinting. So it's a complicated process to someone that doesn't understand their laws, doesn't understand how to speak English. So there's a desperate need for people, lawyers, to help these people try to get through this process. There's different agencies that are doing that. National Immigrant Justice Center is one, and there's other groups that are doing it. Legal Assistance Foundation, Chicago Volunteer Legal Services are doing it. So there's places that you can look to volunteer your time. As I said, you don't have to be an immigration lawyer. A lot of it's straightforward once you get through some basic ideas about it. NIJC is providing training. The other thing National Immigrant Justice Center is always looking for is volunteers to take on asylum cases and go through the process of representing someone in immigration court. It may be a several-year commitment, a lot of commitment of time, but it's a very, very rewarding emotionally process, and you can change somebody's life, not just themselves and children for generations. So I think it's something that I would encourage all of you to think about doing, how you can help either by donating your time, your talent, your money to one of these agencies that are trying to help these tens of thousands of people that have come here. Another group that I'm involved with called Catherine's Caring Cause. And this is a group that's started by two good friends of mine, two 90-year-old nuns at Murphy and Sister Joanne Kirsch. And they have started an organization called Catherine's Caring Cause, named for Catherine McCauley, the founder of the Sisters of Mercy. And they have funded 12 apartments for migrants for families to move into. Their original plan was to raise money for 6 months of rent. Now they're doing it for a year because it often takes 6 to 8 months to get a work permit for these people. There's many groups like that that are providing help. A lot more help is needed. Just encourage all of you to at least think about it. Reach out to these migrants. Because remember, as we talked about for Americans, remember, you're not mistreating aliens, for you were once aliens in the land of Egypt, and you know what it's like to be a stranger. With all that said, I'm going to thank you all very, very much. I think we've run the full time. Cliff, anything else you want from me?
Well, thanks so much. Aviva, are you still there? I don't know if she is, so I'll put out the poll. Hold on a minute. And Roy, you can't do anything with the poll.
Okay.
Apparently. Let's see. So it should be up. Did it come out? Can anybody see it?
I see it, but I won't answer any questions.
Yeah, because if you do it, it gets all screwed up. Steve, can you all see it, right?
Yes,
Okay.
yes, I
You
can.
can fill it out and then you can leave. I got everybody's attendance, I'm pretty sure, but it wouldn't hurt for you to just send a quick email to Aviva thanking her for having you at the seminar today. And we'll get those certificates out.
Thanks. And there's additional handouts that I sent to her this morning. I think she's going to get to you.
Okay,
And
we'll
Steve, I will finish up my outline and get it out as well. Okay.
get them out. And I hope to see a lot of you at my cousin Vinny in a couple weeks.
Okay, Cliff, I'm signing off. Thanks, everybody. Have a good day. Take
All
care.
right.